Good evening, ladies and gentlemen. Thank you so much for joining us for tonight's edition of HR Mentorship Learning Series. My name is Having yet again my friend, my brother, my colleague, Paul Okeshino, and they will be discussing with us this evening on a very important subject, disciplinary policy, a framework that guides employees' conduct during zero litigation. Paul needs little or no introduction. However, I still do the honors. Paul is a strategic, result-driven HR professional with over 7 years' experience in the financial services and fintech space. His expertise spans talent management, people operations, and HR business partnering. He specializes in aligning HR initiatives with organizational goals, fostering employee engagement, and building high-performance cultures. In addition to this, he has successfully partnered with business leaders to solve complex HR challenges, enhance talent management strategies, and also drive organizational goals. He holds a Bachelor's of Science in Business Administration from the University of Ilorin, better by far, and has a Master's in Industrial and Labor Relations from the University of Lagos, combining strong academic knowledge with practical industry experience. Tonight, speaking to us on the topic, disciplinary policy, a framework that guides employees' conduct, HR decision-making, and zero litigation. Let's receive very warmly Paul Okeshino. You have the floor, my brother.
Right. Thank you very much for having me once again on this platform. And good evening to everyone joining us on this call to have this conversation today, which is necessary as an human resource professional, especially in Lagos, Nigeria. Our focus topic for today would be on disciplinary policy. We are looking at it as a framework which guides employees, HR, and also employer to avoid litigations, which we've seen over the years within the industrial court. This conversation will streamline how we make decisions as human resource professional in Nigeria, and the appropriate strikes or warnings that surround misconduct in our place of employment. We've seen cases where HR professionals have handled misconduct within their place of work or environment in a way that is unlawful, as against what was stated in the labor law or by precedents in industrial court. So ladies and gentlemen, as rightly introduced, my name is Paul. Let's take a deep dive and see the areas or table of content we'll be looking at for today's conversation. We'll look at the introduction. Also, we'll look at the disciplinary policy, what it means. We also look at the disciplinary rules, which would structure under minor conduct, major misconduct, sorry, and also gross misconduct, which we must have experienced within our career. We also look at disciplinary procedures, the measures, and also setting up a disciplinary committee which serves as a member or members for fair hearing within the organization. And we'll conclude the conversation with a straightforward case study as stated within the Supreme Court of Nigeria in 1988. So I want you to sit back and relax and join me for today's conversation. Every organization we've seen over time for success in terms of fairness and discipline within the organization would put in place a well-structured disciplinary framework that must have been signed or approved rightly from the HR department to the legal department for review, also for internal control, and also for the business director or the CEO for final sign-off. So these documents would encompass some rules structured in a way to um, control the system. I call it a control measure, right? And also a risk and compliance mitigation within people. There's what we call people, risk, and compliance, and also there's what we call HR audit. All this encompasses what must be imputed in a structured disciplinary policy. The policy also serves as a compass for employee behavior. So what is stated in the policy would be how some employees would behave within the organization. And it is imperative for us as HR professionals to always reinstate or sensitize employees on what is written in this policy alongside the strikes they will be looking at when they go by this policy. The policy is also therefore more than a rule book. It's a framework of trust and also reinforces professionalism within our workspace. It protects employees' rights and also ensures that organizations' values are consistently upheld by guiding conduct, empowering HR also, and also creating a zero litigation culture within your environment. So let's look at what we'll be discussing today. First, we would like to recommunicate what a disciplinary policy is, which by definition of what I have here is a formal framework established by an organization to regulate employees' conduct, applying acceptable behavior or standard of behavior within the organization. So what it connotes is that some certain rules are what is expected of the employee and also shows what is expected of the employer, where HR will now serve as an intermediary to find solutions to what might have spiked the problem within such environments. I also refer it to as a corrective mechanisms within an environment to correct an action, especially when it becomes a bad behavior, regardless of the cadre level within the organization, regardless of the person. This misconduct has been, shared across the HR department for alignment. Also ensuring that disciplinary actions are applied fairly, which is one of the major problems we have because there's sentiment and emotions in our decision making, and we must be consistent and transparent within this framework. That is, what is given to A must be given to B, regardless of either their maybe their environment, their culture, cadre, the person they are within the organization, high performer, etc. All this must be applied as soon as possible. So let's look at the purpose of this policy. The purpose is to maintain a workplace of order. When there are no rules, that means we have an environment where it's destabilized or we have a disruptive environment, unprofessional environment, lacking integrity and trust. And hence, this policy must be well reinstated within your environment. It also protects both employee and also the employer by ensuring fair hearing, due process, and consistency. Minimizing risk, which, like I said earlier, it helps you to minimize the risk. What I can assure you is that for every publication from the Nigeria Industrial Court, the organization name would be mentioned at first, which would be the employee versus the employer. Might be John versus ABC company. Also, the participant of what transpired within the issue would be mentioned. So if you are an HR that gave the wrong warning, the wrong termination of employment, it will be stated and also be accounted for. So it's imperative for us to understand all this litigation issue and align by what is stated in your disciplinary measures, and also which must be in relativity to statutory rules under the labor law or precedents you must have found in industrial court. Provide clarity on consequence of misconduct. So it's one of the major conversations we'll be having today. So if an employee happens to come late, what is the necessary action from the HR or from the organization? And I can assure you, it's not deduction of salary. It's by going through what is stated by law and also look at other things that would safeguard the employer in terms of going by litigations and so on. Let's look at disciplinary policy from the labor law context. We'll be citing some rules or laws or precedents that has been mentioned. I'll be looking at Olatubosun versus NISR in 1988, which would be our major focus for today's conversation, which also be the case study for today's presentation, right? So it's saying that regardless of what you must have spelled out in your disciplinary policy, it must be in correlation with what the law states. So if you have a rule that governs your environment, you must also do what we call comparative human resource management to compare and contrast what is done globally, what is done according to the ILO, what is done according to the Nigerian labor law, or what has been said within the industrial court. So you would reference mostly on the labor law. You would also reference ILO convention. You also reference the Supreme Court. Also has some rights given to employees and also rights given to at least citizens of its country, which must be also embedded in your disciplinary policy. Let's look at one of the key rights stated by the law, right? We look at right to fair hearing. Section 17, subsection 1B of the Constitution of Nigeria emphasize on right to fair hearing for every member of staff within your organization. So should you want to terminate an employment based on misconduct, there must be right to hear what he has to say to defend what must have happened or transpired within the course of the misconduct. This extends to disciplinary procedures by any sanction that must be given to an employee. You must look at areas where you'd want to listen to the employees first before you carry on any investigation. And if you must carry any investigation, you must have exceptional evidence to carry out your findings or your final conclusion based on what you have investigated. Also, termination and dismissal was rightfully stated under the Labor Law Act, Part 5. If you look at Section 11, stating how either parties can terminate an employment, right, which must be justifiable and carried out in line with the terms of employment and due process. We've seen over time where employment is terminated just based on the discretion of the owner of the business, discretion of the management. So all this must go in line with the principle of what we are discussing today, which would connote the disciplinary policy we are looking at. Let's look at case law, audi alteram partem, which means that hear the other side of the story. Should in case you are investigating and you've done your investigation, which would bring you to the disciplinary committee or a query at the first instance to hear the other side of what must have transpired for this employee to act in such way. When those deliberations are looked into, reviewed, then you can now go on to make your decision. This was emphasized by the Supreme Court in the case study we'll be looking at for today. Other areas you'd want to look into is your employment contract, right? If some certain things are not stated on that contract, also not stated in your disciplinary policy or your sanction grid or whatever policies that you found or find in your environment, it is imperative for you to either liaise with your legal department on whatever decision to make on that case. If it's not mentioned at any instance, then you are open for litigation. So that means that you must do what we call annual or within the time frame of 2 years to review your employment contract. Once again, you review your policies. Some organizations review their policy every 2 years, and policies are based on the new normal of what is subjected by the industrial court, or the new normal of what you find in ILO, or by the cases of precedents. So these are more like the guidelines you'd want to put into cognitive in terms of setting up a disciplinary policy. For every part that is missed in your policy, it also states that you are not following the due process which you have aligned in your policy or must have been communicated to employees within your environment. So if there's a misconduct that states that you first give a written warning and you jump to giving a final warning, right, based on what you have stated in your policy or measures, then it becomes an open-ended policy whereby litigation can be filed based on what you must have given to the employees. So it's one of the areas HR professionals need to look at, not to make sure that their career are not in line, because we've seen so many case studies where some actions were carried out by the HR. Of course, we sometimes we understand that it's mostly the business directors or the CEO, especially when it becomes a one-man business, that carry on this instruction. However, as an HR, it's also important for you to give your advisory level to the management, to let them know the situation of what they'll be sharing or what they'll be communicating to the employees if they go on to carry on those instructions. So let's look at the disciplinary rules, which are defined by expected standard by the organization. Some are behavioral, some are one of the major things you would find in maybe if construction, manufacturing. You see employees trying to smuggle things out of the environment. Within the financial sector, you've seen employees moving funds from a client account to another. So let's see what is a general understanding by comparative HRM to what you have to do according to the minor misconduct, the major misconduct, and also the gross misconduct. The rules would show a laid down principles, right? It would give you a step for you to carry out at every interval or at every interference of misconduct in your environment. So when Shadi doesn't come to the office, doesn't communicate, there's a strike for that. First warning. When Shadi does the same thing again, might be second warning based on what your policy is stating. When Shadi does the same thing, might be final warning or termination of employment, regardless of how you have, given the framework of your disciplinary policy to be. Let's look at the first one, minor misconduct. Refers to breaches within the environment that would speak more on behavioral patterns, right? Punctuality, communication issue, tardiness, dressing, etc. like that. They are of less serious intricacies in the business, but it's still unacceptable. However, major misconduct are serious breaches of company rules, right? And of course, they signally disrupt workplace harmony, safety, trust, or operations. Because once this information are being carried out, spread across the entire organization, it becomes a topic for debate on what you as an HR will now decide to do according to your disciplinary policy. I've experienced where an employee had a major misconduct and the set rules from the policy. The employee didn't receive the strike, so it became an issue in the environment. However, another employee did the same thing and was given that same strike. So that's where we're speaking to the consistency of your framework, of you yourself as an HR, of transparency and unbiased judgment within the environment. Gross misconduct, these are very severe of employee conduct, which breaches the fundamental principles between an employer and an employee. You look at fraud, fraudery, the name of the organization, putting it into a disruptive issue, maybe posting on Twitter about the organization in a bad light, and it went haywire, so it becomes an issue. So these are the laid down principles we'll be looking at, and we'll be looking at how we can construct the measures that surround this misconduct within our organization. So let's look at the rules now. Like I stated earlier, we have minor conduct, we have major conduct, and of course we have gross misconduct. They are interwoven when it becomes a major conduct versus gross misconduct. It's also subject to a conversation for another day. But the difference is the height of the misconduct, right? Although a thief is a thief, however. So there are what we call discretion on how it happened and how we can now go on to say it's a major misconduct or it's a minor or gross misconduct. So let's look at minor misconduct now. Tardiness or late arrival. In some environments, they tend to deduct from salary of an employee. I can assure you that the labor law or the Nigeria Industrial Court frowns at this method of discipline, right? So unauthorized or persistent absence, it's a minor misconduct where an employee do not tend to communicate as soon as possible of unauthorized absence from work, which would always, be an issue between an employee and the line manager, right? Also, abuse of break or lunch period is a minor misconduct. Failure to follow sickness, absence, reporting rules, minor damage to company property, minor misconduct, spreading rumors, gossip, or slander, poor personal hygiene. Of course, it is an issue, especially in Lagos, where we tend to go to work and, perceive some, smell within an environment. Of course, sometimes HR tend to communicate with the employee as soon as possible. Use of absence or offensive language is a minor misconduct which must be condoned within an environment. Causing unnecessary noise or disturbance. Some organizations will have principles at zero noise, especially your phone volume, ringing tone, etc. One of the things I've seen lately is selling goods and services on company's premises, right? Depending on what the organization is stating clearly on this issue. But you'd see some employees even using their CUG line to post something on their status, and share goods and services. Some sell chin, some sell recharge card and etc. Depending on what the organization wants to allow in such an environment. And you would agree with me that sometimes it disrupts the flow within the organization. So sleeping or eating in the office, which would go to number 3 under the minor misconduct now, right? So you'd want to make sure that you are there to the lunch period stated by your organization. Some would say 1 hour break. Some would give a variance or range between 12 noon to 3 p.m. Just to make sure that employees observe their break hour or eating period within an organization. So let's look at major misconduct, which would spike so many issues within an environment. Of course, after this, we'll be looking at the strikes, right? One step at a time. So let's look at the major misconduct. Harassment and bullying, one of the major issues you'd find within our environment, especially when it becomes a gender issue. Discrimination also is a bad behavior within an environment. Verbal abuse, threat, intimidation, fighting or physical alterations within the organization. All these must be stated clearly in your disciplinary measures to these things. Breach of confidentiality or misuse of company information is one of the problem we are facing currently in Nigeria, and that's why you have your IT department setting up firewall protocols, the kind of flash drive you need to accept on your system, um, 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 data policy within your environment also. You look at conflict of interest or unauthorized external work affecting performance. This focus would be for my tech bros, right? Now they tend to move jobs. They could be interfacing with one fintech and move to another fintech, all in the space of trying to, get more income. So conflict of interest, well spelled out within an organization, would be stated under major misconduct. Repeated act of minor misconduct despite warning. This would speak to minor misconduct. So if you have been warned several times about a set act you do or misconduct you do over time, then it will lead to major misconduct. For example, if you come late often, and this has been discussed, addressed, warning has been shared, then it becomes an act of major misconduct. Serious breach of health and safety rules and that endanger oneself or others, unauthorized access to restricted areas, system, or record, which would rephrase it down to the policy under data management, right? Deliberate disregard of company policy. Even disregard for your disciplinary policy is also a strike for major misconduct within a standard environment. Let's move on. Let's look at um, the gross misconduct now. Looking at the gross misconduct, we'll just touch light on some few. Conviction of a crime that does not carry the option of a fine or crime involving dishonesty, right? Falsification of result, document that you must have shared with HR or within the organization, alteration, forgery of certificates, records, or company's documents just to get more clients or what have you within an environment. Possession of firearm. I don't think I've interfaced with this. We are talking about guns, knife within your environment, dangerous weapons or explosives within the company's premises. Any form of harassment, any form can be sexual, which is very, very key to organization, verbal, physical, or psychological towards employee, right, client, or stakeholders. Intimidation, coercing, or inciting employees to violence or disorderliness conduct. I once remember a policy that was rewritten within my organization based on an employee going for a political appointment. So we had to quickly write a policy on that right after we've observed the incidents and issue that it caused the organization. So what I'm trying to say is that sometimes policy becomes an input of what has transpired within your environment, either internal or external, right? Can be a customer relating, can be within your computer system, can be within your technology, can be the people themselves. And when it's external, of course, you know that these are factors that are beyond the business as we are, acronym them to be PESTU, political, economical, socio-cultural, technological factors that could improve your policies over time. You also want to look at unauthorized possession of company property, right? And this would look at my people majorly in the factory business. There was one time an HR reached out to me of working in a mart in a supermarket, and most of the employees at the end of the day they sneak in goods within the supermarket out to resell or for their own use. In some environments, in most environments, don't let me say some, and the strike is dismissal immediately, right? Theft, bribery, fraud, or unauthorized removal of company or personal property for the company's premises. I'll look at bribery now, and that's why sometimes it's hard for HR to receive financial support from employees because you don't know what they'll coin it to, right? So this is where I gave you about this sum to help me do this. And of course, employees are very, very wise. So it's important for us to be professional at what we do within an environment and be cautious of the people we also relate to, because this strike would be automatic dismissal within the environment. Unauthorized disclosure of trade secrets, business strategies, or confidential companies' client information. Speaking to this, I find HR also wanting in this because over time I've seen HR ask for another HR policy within its organization. For example, you would see people requesting for your own policy. You sharing such policy, it's a breach of confidentiality of the company's property, because those policy, if you look at it, it's clearly stated that it's an internal use, right? So it's important for us to know what we are sharing with people. If you work with the financial sector, you would see unauthorized disclosure of trade secrets, FX business, treasury management, fund management, asset management, all this kind of gross misconduct. We interface with systems like that. Not only that, you find them in manufacturing also, and also in the trading businesses. Let's look at disciplinary procedures, right? What are the things we need to be aware of before we can now say that these are the strikes we want to give, or we want to set as laid down rules for all the misconduct we have mentioned, or let's say quite a few of the misconduct we have mentioned, right? A disciplinary procedure is a structured process that organizations use to address employees' misconduct. That is one, poor performance. And all these, I can assure you, are stated in the labor law, right? Especially the poor performance, which states that you can terminate an employment based on poor performance, but you must have set your weightage system to speak to those who would have poor performance in your performance management framework. You see termination based on redundancy and restructuring, right? So those are the avenues, the legal basis in Nigeria will state clearly of when you can terminate an employment, which is misconduct, poor performance, restructuring, or total closure of a particular business. Other would come from breach of workplace rules, transparency, and consistent manner. So this procedure will set up the steps management would follow, from investigation to hearing to decision making, and either corrective actions or sanctions. One of the experience you would have in a disciplinary committee is how, because for such situation to happen is a loophole in a system, right? So when it happens, it's important for you to go back to that policy and readdress the issue. Or sometimes it's in your standard of operating procedure. You would see theft issue in workflow from either operations to sales to finance to treasury, regardless of how the workflow is. What are the SOPs that are set within this department for alignment? Employees are very wise, so they tend to look at the loopholes where they can commit fraud easily within the system to make sure that at least within the first 4 years or 5 years, it's unknown to any party, right? So all this, the disciplinary procedure would allow you to go back, refer to that case, and come back and redirect yourself in either your SOP or your disciplinary procedures along the line. A perfect example is the teller you see in the banks, right? You would see the denomination stated there is because of some breaches that maybe the teller must have made mistakes over time. So they want the customer to write the denomination of Naira figure on that teller receipt for them to know or to track the issues when they are trying to investigate such issues they have within our environment. So all these procedures, they don't come in a vacuum, right? They are based on some intricacies that you must have seen within your environment. So it's important for you as an HR person to go back to your policy and infuse the process back again and make it a rule within the environment. Legal basis in Nigeria, you look at Labor Law Act 2024, you look at the Fair Hearing Constitution under the Section 36 of the 1999 Constitution. Let's look at what it states. It says, for every procedure, employees must be aware of the allegation against them. That's the first principle. They must also be given an opportunity to respond. It's not that after your investigation, you found Tunde wanting of theft or fraud case, immediately you dismiss, right? You need to let the employee respond to what transpired within that case. You must not punish without a fair hearing, which is the basis of our conversation today, which the topic would say zero litigation. I can assure you that once you've done this due process, the risk is minimal. We have low, medium, and high risk, which my risk people would understand in their own department. So you've reduced a termination process from high risk to a low or zero risk within your environment. And also, there's also what we call the compliance part of the risk, which is why some would say risk and compliance. So you are complying to what the law is stating. You're also not only complying to what the law is stating, but what your disciplinary procedure has mentioned or refer in your policy or disciplinary policy that must have been stated. So failure to go by these laws would, of course, employees would go to file litigation, Supreme Court, Industrial Court, just to find, legal damages that they must have caused to their name or within the environment, and see how they can get the same back on track. So let's look at the measure table, which is one of the problems we've seen over time, because we tend to, I know majority of us would have this in our environment, but somehow we omit the first strike and go to the second strike. Sometimes we even omit the first and second strike and go to the third. And in most cases, we've seen where you miss the first, second, third strike and go to the fourth, right? This is what is said to be more like a global standard on how the measure table must be done. And it's important for you to use this table, and you would see some disciplinary measure and see deduct 5,000 naira, deduct 10,000 naira for coming late. Of course, these are bases of where employees do not have room to file litigations. But if you do it for senior people, immediately they will look at the grounds. They would consult lawyers to see avenues whereby they want to make sure that the organization pay for the bad deed they must have done for these employees. So for every minor misconduct, right, you look at the first step, which is verbal warning. Some would say verbal warning or canceling, because they are just behavioral, most are behavioral issues within your environment, right? Then you look at the written warning. This is right after the employee must have committed the same issue or the same minor conduct that has been done within the environment. Then thirdly, or the third strike would focus on a final written warning, well dated, right? And the last one will be dismissal. For every strike, you must also learn to hear from the side of the employee. And before you go on to dismissal, you must set up a disciplinary committee to come and, okay, look, on so date you were warned verbally on this issue. On another date, you were given a written warning on this same issue. On the third time, so date, you were given a final written warning on this issue also, or a different issue that also would be under the subject of a minor misconduct, and hence, can you state reasons why disciplinary actions should not be carried against you or dismissal? Then you hear from the employee. Then if it's not subjective enough to what has been communicated over time, then you can go on to dismiss such an employee. Of course, the first warning, the second warning, and the third warning must be well documented because that is your own evidence of what has transpired over time around the employee. You look at major misconduct, written warning, then you go on to final written warning, and the third strike would be dismissal. In some environment, you would see the replacement of written warning to final warning because we said major misconduct is something disrupting the environment, right? And also, if you look at the gross misconduct part, you see where it stated that it shows final written warning, and some would just be automatic dismissal. However, you must also conduct a disciplinary committee must be set up for proceedings to listen to the employees. Now, if all these are within your environment, what then does the disciplinary committee do to ensure fairness and transparency within your environment? Let's look at what the DC committee would be doing just to make sure that they go in line with what the Supreme Court have stated, or the labor law, or ILO convention, or let's say precedents in the Nigeria Industrial Court. The disciplinary committee is a formal constituted body within the organization. They are responsible for handling cases of employee misconduct, performance breaches, or grievances that require investigation and fair hearing, right? So it's a decision-making panel where it would consist of odd numbers of people sitting down to discuss the issues at hand and how to resolve this issue, or what to do to such employee within your environment. Let's look at the composition. A DC must constitute a chairman, right? A chairman would be someone that has been mentioned in your policy to be the chairman of the DC committee. Most organizations will use group head legal, group head internal control, group head risk and compliance, because all these three mentioned, they are like a control system within your organization, right? Then HR representative can be group head HR or HR manager. Also, you look at the head of department, line manager also. You look at senior manager. These are members now, right? In some cases, if the case is very high, more like a senior manager issue, some members of the board would sit in the DC. Then you have legal and compliance department. They would give an officer or a manager to be responsible for them. Lastly, if your environment is unionized, then you tend to bring a union representative of the employee. So it's also within the law that an employee must be given the right to be represented in your DC committee. So might not necessarily be a lawyer, but someone who can represent the employee within the organization. Why is this important? Promote objectivity, right? Decisions aren't left to one person. Your decision is not left to the HR, because any decision made in that environment will either make or mar the organization. And you see it over time where publication and even Google, even Twitter litigation has been filed during the era when Elon Musk was terminating employment of those who were previously there on Twitter, right? You would see large organizations that we might not want to mention names now, protect the company against claims of bias, wrongful termination, or unfair labor practices. So if you look at the formation of your DC committee, there are people who must understand, one, the labor law as number one. That's why you would see the legal and compliance department, right? Sometimes you see in an environment, they have a internal legal counsel, litigation officer, depending on how large the organization is. Builds employee trust in the system by ensuring transparency and fairness. In my own environment, that is in my own organization, every Friday we tend to do a nugget to communicate what is being stated in our policy to employees, because sometimes they tend to forget the laid down rules within your environment. And lastly, it strengthens your HR decision making and reduce the risk of litigation, which is the heavyweight to this conversation. If you can reduce the risk of litigation in your environment, that means you are duly focusing or following the disciplinary measures or actions or procedures or policy that you must have established within your organization. Let's look at a well-known case study, which was the foundation of fair hearing in Nigeria. Look at Olatunbosun versus NISER Council in 1988. What was the problem? Tunbosun believed that he was terminated unlawfully, right? And he was arguing that his case wasn't heard, and hence his termination was unlawful. But let's see what the Industrial Court or the Supreme Court had to say. Let's look at the facts of the case. Tunbosun was a senior research fellow at the Nigeria Institute of Social and Economic Research, right? Allegations were made against him regarding misconduct and inefficiency within the organization. What did NSER Council did? First, they set up a panel of inquiry to investigate him, right? Which is your normal investigation. Let's investigate this matter. Once we investigate, we communicate, we query him to come and discuss all this investigation. Of course, the word allegedly would be mentioned because it's yet to be a statement of a fact after the DC, right? Olatunbosun was invited to appear before the panel and given an opportunity to defend himself. Right after the investigation, the council terminated his employment based on that they have, followed the due process on this subject matter. The legal issue, the litigation filed by Olatunbosun were challenged by cases of dismissal, right? Arguing that he was not given a fair hearing and was dismissed unlawfully. The key question before the court was whether the procedure followed by the NISER satisfied the principle of fair hearing, which is Section 33, subsection 1 of the 1979 then Constitution, which is now Section 36 now in the 1999 Constitution. You can see the reference, right? Let's look at what the court's decision were. Number one, they believed that Olatunbosun was given the right avenue for fair hearing since he was invited to appear and defend the claims, the investigation that have been made by the council, which is, in fact, the most important part of the investigation. The court also emphasized that fair hearing doesn't mean a full trial in the court of law, but that the person must be given a reasonable opportunity to be heard before final judgment. Once these rules of natural justice, that is, hear the other side, is done, then the employer has every right to terminate such employment within that environment, especially on the basis that also these procedures were mentioned in their disciplinary policy or sanction grid or HR policy they must have had then or within their environment. So in a nutshell, what are we trying to say? We are trying to say that for every misconduct by an employee, it's important for you to go back to what is the laid down principles, the laid down procedures for your disciplinary action. For every strike, there's a principle that says for every action there is a reaction, right? So something cannot just happen without a movement. So hence you need to look at your policy. What does it say? What does the Constitution says about fair hearing, or based on what happened or what must have transpired within your environment. So when you go down these procedures, then you are following what we call due diligence in the risk and compliance space of the HR department. And this solidify your experience over time as an HR person, as an HR manager, for better decision making. Also formulate a means of advisory, right, to the top level management on the processes they need to follow before making decisions as regards the employee. So that'll be all from me for today. If you have any question, if you have any observation, if you have any addition to this conversation to enlighten HR professionals like me, we are very open to taking them. Thank you very much. Over to you, Dr. Oluyemi Adeosun.
Thank you so much for that was sense. Instructive, very, very informative and educational. Ladies and gentlemen, we would like to take contributions, comments, questions tonight's subject matter. You want to share an experience? This is the opportunity to clear. We can give the floor to you. Thank you all for pulling this through. I have thoroughly enjoyed myself.
Doctor, your network is dragging. What are issues? Okay, you know what? Let me just take over. Let me take questions. Noah, you have the floor. I can see your hand. Okay.
Okay, good evening to you. Good evening, everyone.
Good evening, sir.
Thank you so much for the delivery of tonight's lecture. I believe it's a kind of a timely for me because all what was discussed, there's a particular case at hand that I'm actually undergoing in the office currently with regard to late coming and how to handle it. So it's a kind of an eye-opener to me based on what I have received tonight, and which I believe is a good way to go. My question is, in terms of this late coming of a thing, some staff are persistent and the senior manager at the senior manager level, and it's spotted out on having discussed with the CEO, and it's as if you are almost at the same level with the manager, and whatsoever you say as HR is as if it's not welcome and it's not ready to like listen to what you are saying. And maybe the CEO is somehow quiet. And the same person sometimes also excuses. I won't be able to come to the office today, impromptu. So in that kind of scenario, how do we handle that kind of situation?
All right. Thank you very much. I've also been in the situation of this. So what I did, ideally,
Yes.
was to track every cases where this said employee has, asked for excuse over time. I can assure you that it was up to 11, right?
Okay.
In the space of, let's say 6 months,
Okay.
always taking excuse. These were key facts me sending to the top level management because, of course, that person was a senior manager on the areas where the senior manager asked to improve on, right? Especially when it was sent to the line manager. The line manager happens to be the CEO of the business, right? So this was communicated to the CEO of the business, which is the line manager of that person. On the instances, this person has flouted the HR policy on punctuality. Once email communication has been shared, we would await for the line manager concurrence and see where we can now take the strikes on punctuality, which has been stated by your procedures or manual. Now, it's also important for you to use your discretion at this point, right? Sometimes you would reroute it through after maybe the feedback from the CEO back and forth. Mostly you would see high performers within your environment going by all these things because they believe that they cannot be replaced, right?
Yeah.
First,
That
it
is right.
becomes a culture thing, which number one must be addressed. Two, it becomes what the team members, I don't want to use subordinate now, will be seeing the line manager in that kind of picture, right? The subordinate will tend to not to come early because the supervisor also is not always early at work. So in a nutshell, you follow due procedure, communicate to the line manager, let them be aware of the situation and the repercussion effect to the department and to the organization because it becomes a precedent within your environment on such areas. Everybody can now say, oh, but look at Mr. John, he's just coming in. But for me, I'm being warned because I came in late. So you must be transparent and fair enough. So first situation, explore your data from all the messages or emails that might have been sent to the HR department or situations whereby they get to clock in and clock out, right? Share it with the top level management of this case and your own advice to the management. Of course, you also look at your L&D in terms of attention to details, punctuality, and etc. within your environment. But you must be tactful because it's a senior manager and you know how they do within the environment.
Yes. Thank you so much, Mr. Paul. I really appreciate it. Thank you so much.
You're welcome.
More grace, sir. Thank you. I really enjoyed the delivery tonight.
Thank you. Okay, let's see Messi. I can see Messi hand. Let me ask to unmute.
Okay, hi, good evening.
Good evening, Ma.
Thank you very much, sir, for this wonderful session. I really enjoyed it. Okay, a quick one. My question goes this way. So, during the course of your training or teaching, you say that it is against the labor law for an employer to deduct a staff salary for lateness. So I would like to ask, because currently in my organization, that's what we do. That's the policy, and everybody knows about it. So if you're late, what the sanction is deduction. Deduction is being done at the during payroll period. We deduct the payroll specialist. We have a way we calculate it, and it's being deducted. So, but now that you're saying that it's against the labor law, what other measures can be put? Because to be sincere, in my organization, if we want to go by, okay, is to give a warning, or we counsel them, give warning, and then we terminate. Apparently, like 60% of our workforce will terminate them within 1 month, because they are so used to coming to work late. Our official resumption time is 8 o'clock, and still company gives grace period for 30 minutes. So 8:31, you still see people coming in by 8:35, 9 o'clock past 9. And we've talked, we've issued, HROs, we've tried to find a way to say, okay, what's the issue? It's not like there's a major roadblock or there's something. People just like coming to work late. So I don't know.
All right. I think I've said this over time. If the repercussion of me coming late to my own office is to deduct, it means that there are some days I'll just decide to sleep on my bed and not come to the office, and I expect them to deduct from my salary. As far as deduction is being made, I think I'm okay. Since I can come in late at any time, deduction is being made, then you go ahead, right? In some environments, it's stated in your disciplinary action that, okay, coming late, you take deduction of 2,000 naira. The principle is not stated. They didn't state it clearly in the labor law. Nowhere was it stated. But in the case whereby it's not stated, it's also very important for us not to imbibe it in our culture. I can assure you, if an employee is being warned severally on late coming, unless your environment allows you to do other jobs where your employee can also attend to other jobs, maybe they are on contract, then it becomes an issue, right? So if an employee comes in late, gets the first strike, get the second strike, the third one, and the fourth one, and you are trying to understand why this employee is always coming in late every time, right? Then if terminated is given to such employee, I can tell you that no litigation will be filed and will be won against the organization. And it becomes a precedent in the organization that an employee was sacked because of constant coming in late. Then others will be addressed. But when it becomes a culture of remove 1K, remove 2K today, remove 1K today, remove 2K today, I also would sit at home confidently. Because if you deduct like almost 20K from my salary in a month because I'm coming in late, fair. If I can come in 10 as the CEO, it's fair. But when you give a sanction based on the steps we've said today, that you're coming in late, first warning, it becomes current, concurrent, second warning, it's repetitive, third warning, which are stated in your procedure, and they see that the last strike will be termination of employment. Just one person, you would begin to see changes in people or the numbers of people who come in late. In fact, they keep on telling themselves that, look, help me, oh, I'm almost coming late, oh. But because you've created an open-ended system, and hence, In fact, they'll be happy. In fact, I'll be happy if such thing is created in your environment. Because when I wake up, I see 8 a.m. I'll go back to bed because I know you are deducting 2,000 naira. So one thing about policy, you must also understand that it must not be open-ended. So you need to create it in a structure whereby, one, even cultivating a culture of punctuality, you address that. You create a learning platform whereby all employees are aware, verbally, written, that look, these are the procedures we want to go on now based on punctuality. Of course, it's very hard to to move from that kind of procedure to this new set of procedure, especially in the manufacturing environment, where we have precarious work. People can come in anytime, factory workers can come in anytime, you understand. But in a standard environment that is worthy to be a standard environment, once you put this disciplinary measure into place, I can assure you, if you terminate an employment, at least 80% of people coming in late will be addressed. So, but when you create a room whereby you deduct this month, you deduct next month, I'm okay with it, just for my sanity, right? Also, what you might also want to do is bring up the minute at which people come in late from 8:30 to 8:15, and say if you come in within 8 to 8:15, then you are late, and send a warning to an employee. The employee becomes an advocate of your policy. Oh, I was given a final warning. If I'm found coming in late, then I'm terminated, because on your final warning, it's been stated of the next step after this. So employees would work on how they would come into the environment very early. So that's just my take on the basis of punctuality. If you create a procedure whereby people can easily flout, just imagine someone earning 2 million naira and you are deducting 2,000 naira every month. The person would come in late. When they wake up and see they are tired, in fact, they come in 11 because it's the same cost of coming in late. All right. I hope I've answered your question. Let me move to Abisoye Oyebo. Let me unmute. You have the floor, man, please.
All right. Thank you very much. Good evening, everyone. So much. During your presentation, when you had the policies, the sanction grades, and all of that, you said that it should be updated. So I was not thinking that, okay, so like there are new laws in that happen, like new laws, maybe labor law or something, all these cases. Is there a particular place that you will be able to get all this information, so that when you're reviewing your
Yes,
policy, you'll be able to change, like, okay, this rule
if
is no longer applicable here, I adjust this or that.
if you are a member of the HR mentorship, Dr. Oluyemi himself would post judgment in industrial court. I think I saw one last 2 weeks, right, versus a bank, right? It becomes a basis of your procedure. Let me take, for instance, there's a court judgment on probation period. And what does the court say? The court said that in your offer of employment, you mentioned that this employee has 6 months of probation. There was no place stated in your policy nor in your offer of employment to increase the probationary period to 9 months.
Yes.
And the court said you must pay damages because you didn't mention in your policy that you are increasing it to. So if your letter of contract that was signed, duly signed by you as an employer of labor, and also the employee is duly signed as 6 months, then your judgment after 6 months, either the performance being met or not met, is termination, unless provided it is mentioned in the contract, because there is no law that guides that probation, but there's a precedent that guides that. Since you didn't mention it in your offer of employment, why should you initiate such clause? Hence, unlawful termination of employment. You can see the issue. The employer was even doing the employee the good to come back and prove his or herself that, look, I can still meet these KPIs. But when the issue was transferred to the courts, then it becomes a litigation issue of something the employer was even trying to help the employee.
Sure.
But the court is saying that, was it mentioned in the offer of employment to increase such probation? So what the law is stating here is that as far as some laws are not mentioned, of course, you must mention it in your offer of employment or your disciplinary policy, or as the case may be. So when you get informations like that, you jot it down for, there's what we call policy review committee also, which would conform of the legal department, the internal control, the risk and compliance, which are the power department for all standard of operating procedures in your organization, and you as an HR person also.
All right. Thank you very much.
You're welcome. All right. Any further questions? Let's take questions before we call it a day. Does the disciplinary committee have to include officers? No. You would look at senior management or group head, right? So if you have group head internal control, he or she must be there, group head legal department, or company secretary or litigation manager must be there, HR must be there, line manager of the employee must be there, chairman can be a risk and compliance person, can be the company secretary, can be HR, can be internal control, must be there. But what you must understand that someone who has a close relationship with that employee, you must avoid having such person as a member of the disciplinary committee to give an unbiased decision with such situation the employer has committed. For example, if you notice that the group head of internal control is closer to the group head of finance, and the group head of finance is into a fraudulent activity, right? You have the right to take out such person, that is by observation, and bring in those who would come in and give unbiased judgment on the case. All right, I'll take the last question. I can see Michael. You have the floor, sir.
Good evening.
Good evening, sir. Yes, please.
Yeah, I want to first of all appreciate Mr. Paul Okeshina for the brilliant performance. My question is around composition of disciplinary committee. You highlighted 6 categories of people that can be composed of the disciplinary committee, and you are talking about odd number of people. These 6 categories is within odd. Are we going to provide one more category or person
So
to make it odd?
So you can set it up to be 3, 5, 7, 9, but it must not be even. Why? Because you need to get the buy-in of 2/3 of that committee. So if it's even and 4 says no, it's okay, he's our guy, and 4 is saying no, he did something wrong, hence dismissal, then it becomes an issue. So it must be 2/3. That is, 1 vote must be over the other. But in most cases, when investigation is being done thoroughly, most of them don't have any buying than to accept what your procedure must have mentioned in the policy.
Okay, all right. Thank you.
All right. We're fast behind time. I think that will be all from us. I can see another question. Let me just take this last question. At what time does the disciplinary committee have to be set up? At the point of when you have done your investigation and what your policy says is termination. Because for every warning, recall there's a query. Query is a form of fair hearing. So query is not a warning. Query is you requesting for what transpired from the employee. So when you query an employee, you are inquiring of what happened. So when you send a query and the employee respond, and you respond that after further review of your response, it means that you flouted our policy. Hence, first warning. When that same employee does another thing, you send a query again, inquiring of what happened. The employee respond. You also refer to what has transpired before as a precedent. Looking at what you've done in so dates, minor misconduct. Today again, take this as a final warning. At the point whereby it's not subjected to termination or dismissal, you set up your disciplinary committee showing the first warning, the second warning, which is part of what have happened, and also the current issue, which is part of your investigation, will be submitted to the chairman, and the chairman will now address the member first, letting them know why they are here in this committee. Once they begin to call the employee, they will also allow them know why they are here. Then question will be asked. HR or the secretary will be taking minutes. Most and every case, most employee will sign a document because most of what they are saying will be recorded or imputed in the database. So they must sign a policy or a form to show that they consent to the conversation being recorded within the DC committee. Okay, I'll take this last question. I have Mercy. You have the floor.
Thank you very much, sir. Please, I would like to ask, I saw a conversation on LinkedIn recently, days back, regarding who is supposed to send a query. So some people said it's supposed to be the line manager of the employee. Some said HR. Some said in a place where the line manager is not on sick, maybe on leave, the HR can then send a query. So I would like to ask, which is the best practice? Who is supposed to send a query, HR or line manager?
Okay, so it depends on I don't want to say it's the line manager, right? But in most cases, in a standard environment, the line manager reports to HR on what happened, right? Inside that report, the line manager can also respond to the employee, the team member, on why he or she is late to work. Because the line manager is like the supervisor. The line manager will be aware of when an employee comes late to work or not, right? So in most standard, the line manager reports the situation with the employee in copy of that email. HR will now respond, "Dear John, sequel to our email from your line manager, before the close of business, please communicate to us why disciplinary action should not be carried against you as regarding the subject matter." Full stop. So in a sane environment, the line manager escalates to HR of what has transpired between either the line manager or the employee. So it's not a direct answer question, but rather of what transpired. It might be a situation that transpired between the line manager and the employee. It will not be a case of who first reports to police, not be him the win case. All right. I have Aliu. Let me unmute you. You have the floor, sir. Okay, I've been trying to. Okay, you have the floor.
Hello, good evening, everyone.
Good evening, sir.
Yeah, thank you very much for this insightful presentation. It's quite of eye-opening. So, in response to the question that Mercy just asked. I know this has been a very serious, controversial case and all of that.
Yeah.
In my understanding, like you rightly said, the supervisor is the one that is aware that you are coming late to work or you are not at work at all. So what I understand and what I am used to is your supervisor asks you a question. Query, what people say as query is just a question.
100%. 100%.
Yeah. Your supervisor writes to you, on so date or today we observe that you come late to work. Please, can you explain what happened?
Yeah.
You explain, and in some cases, it is advisable that the supervisor puts HRO in copy of that question. So when the subordinate now responds, it is only when the supervisor is not convinced or is not okay with it, he cannot ask HRO to take it off from there or advise the step. Yeah, thank you very much. That
well
is
said. And that's why I mentioned it depends on the issue that was raised. If HR saw the situation, HR can respond. But as a supervisor, you have an overview on your employee. So you then ask question with HR in copy, then HR would take it from there for every necessary action that must be done in line with what we are discussing today. Thank you very much, Ali, for that. All right, it's almost past time. I think that will be all from us. We thank you very much for joining us today. If Doctor is still there, Doctor, you have the floor. Any other addition you have to say before we say our very bye-byes?
Thank you so much. Ladies and gentlemen, let's unmute and thank Paul Okeshino. At least we won't meet in court. Now you hear go to court. And if they say go to court, we are happy to put them there. Thank you so much, Paul.
Thank you so much. Thank you so much.
Thank you so much. Thank you very much. Thank you.
Thank you so much, Dr.